All of Western culture is at war. The fundamental point of conflict is whether a person's gender is determined by biology or psychology, reality or wishes. Now, one of the latest battles in this war is the Supreme Court case United States versus Skrmetti. In this case, Mr. Skrmetti, as Attorney General of the state of Tennessee, is defending the state's law that prohibits the use of so-called gender-affirming care for minors. The answer the court came to will surprise some and infuriate others. So we'll look at that next on the Constitution Study.
Love the neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution, teach your rising generation be free. It's amazing to think, just a few years ago, it seems, the idea of transgender was unthinkable. Sure, you had cross-dressers and transvestites and all the lot, but the idea that suddenly that would become normal, that we would actually mutilate our children in this idea of gender bending, well, that's where we are, which is why this case is so important. Now, if you want to find out more about the case, I wrote an article where you can find all the links to all my source material so you can double check my work. You'll find that at constitutionstudy.com. Just look for the article. You can also sign up for a mailing list or several other things. I'll talk more about the website and some other things at the end of the episode. But for now, let's take a look at this case, United States versus Skrmetti. When we declared independence from Great Britain, our founding fathers clearly stated that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. The case United States versus Skrmetti is ultimately a controversy about rights. Do minors have the right to treatments that permanently alter their bodies? Or does the state have the right and duty to protect these children from harm? In 2023, Tennessee joined a growing number of states restricting sex transition treatments for minors by enacting the prohibition on medical procedures performed on minors related to sexual identity, known as Senate Bill 1, or SB 1. As is so often the case, the details matter. What was in the law that got the United States government to intervene in this case brought by a group in Tennessee? SB 1 prohibits healthcare providers from prescribing, administering, or dispensing puberty blockers or hormones to any minor for the purpose of enabling the minor to identify with or live as a purported identity inconsistent with the minor's biological sex, or treating purported discomfort or distress from a discordance between a minor's biological sex and asserted identity. Now, Tennessee didn't prohibit the use of puberty blockers or hormones to anyone, only to minors. This is important because in this country, not only are minors unable to give consent, the state is expected to step in when a child is being harmed, even by their parents. It's one of the few situations where the state can legitimately interfere with the parents' rights when the health or safety of the child is at risk. That said, SB 1 is not a universal prohibition on the use of these drugs. At the same time, SB 1 permits a healthcare provider to administer puberty blockers or hormones to treat a minor's congenital defect, precocious puberty, disease, or physical injury. In other words, SB 1 only prohibits the use of puberty blockers and hormones when the purpose involves encouraging a transgender lifestyle. This case, of course, did not start at the Supreme Court level. 3 transgender minors, their parents, and a doctor challenged SB 1 under the Equal Protection Clause of the 14th Amendment. The district court partially enjoined SB 1, finding that transgender individuals constitute a quasi-suspect class, that SB 1 discriminates on the basis of sex and transgender status, and that SB 1 was unlikely to survive intermediate scrutiny. The Sixth Circuit reversed, holding that the law did not trigger heightened scrutiny and satisfied rational basis review. The court granted certiorari to decide whether SB 1 violates the Equal Protection Clause. The district court found for the minors, their parents, and the doctor. The court claimed that people believing they are transgender are part of a quasi-suspect class, which we'll go into more in the section on levels of scrutiny. Based solely on the belief that so-called transgender people are more likely to suffer discrimination, they claimed Tennessee's SB 1 was unconstitutional. However, the Sixth Circuit disagreed, claiming that the district court was wrong in how they evaluated the law. The Supreme Court took the case to decide if SB 1 violates the Equal Protection Clause of the 14th Amendment or not. This judicial scrutiny doctrine is a creation of the Supreme Court as a way of indicating to lower courts how hard a government must work in order to be allowed to violate your rights. The lowest level of scrutiny is rational basis test, which is a judicial standard of review that examines whether a legislation had a reasonable and not an arbitrary basis for enacting a particular statute. Basically, when the court uses the rational basis test, they're just looking for a good reason for the law, rule, or regulation to exist. Next comes intermediate scrutiny, which is, in order to overcome the intermediate scrutiny test, it must be shown that the law or policy being challenged furthers an important government interest by means that are substantially related to that interest. In order to survive intermediate scrutiny, the court requires not only that the law or policy be reasonable, but that it furthers an important government interest. Lastly, we have strict scrutiny, a standard of judicial review for a challenged policy in which the court presumes a policy to be invalid unless the government can demonstrate a compelling interest to justify the policy. Under strict scrutiny, the government must show not only their interest is important, but compelling. What these court-created definitions seem to miss is the primary interest of government. From the Declaration of Independence, we read that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. Government's first and primary interest is in securing the rights of the people, not working out ways government will be allowed to infringe on those rights. This is where the district court's claim about quasi-suspect class comes in. A suspect class is a presumably unconstitutional distinction made between individuals on the basis of race, national origin, alienage, or religious affiliation in a statute, ordinance, regulation, or policy. Now, when the Free Legal Dictionary uses the phrase presumptively unconstitutional, it's rather ironic. You see, the dictionary is claiming that when a distinction is made based on race, religion, etc., it's presumptively unconstitutional. The irony comes in when we realize that putting people in classes for the purpose of special protection under the law is presumptively unconstitutional. It truly is a violation of the concept of equal protection under the law. The petitioners claim that Tennessee's SB 1 violates the Equal Protection Clause of the 14th Amendment, which reads, "No state shall deny to any person within its jurisdiction the equal protection of the laws." So how can the petitioners claim a violation of the Equal Protection Clause? On its face, SB 1 incorporates two classifications, one based on age, allowing certain medical treatments for adults but not minors, and another based on medical use, permitting puberty blockers and hormones for minors to treat certain conditions, but not to treat gender dysphoria, gender identity disorder, or gender incongruence. Classifications based on age or medical use are subject to only rational basis review. The plaintiffs argue that SB 1 warrants heightened scrutiny because it relies on sex-based classifications. But neither of the above classifications turns on sex. Rather, SB 1 prohibits healthcare providers from administering puberty blockers or hormones to minors for certain medical uses regardless of a minor's sex. While SB 1's prohibition references sex, the court has never suggested that the mere reference to sex is sufficient to trigger heightened scrutiny, and such an approach would be especially inappropriate in the medical context, where some treatments and procedures are uniquely bound up in sex. The Supreme Court has established a precedent that classification based on age and medical use only requires rational basis review. Remember, this is not law, but the history of the court. Now, while the petitioners, the plaintiffs in the original case, argue that because the classifications are sex-based, they should receive a higher level of scrutiny, I find this laughable for two reasons. First, the transgender movement keeps claiming that sex and gender are different. So if SB 1 prohibits the use of these drugs for gender identification, how is that sex discrimination? Second, SB 1 doesn't discriminate based on sex since the sex of the recipient is not a consideration. The application of SB 1, moreover, does not turn on sex. The law does not prohibit medical treatments for minors of one sex while allowing those same treatments for minors of opposite sex. SB 1 does not exclude any individual from medical treatments on the basis of transgender status. Justice Thomas made an interesting point about the expertise and consensus in his concurrence. The United States asserted that the medical community and the nation's leading hospitals overwhelmingly agree with the government's position that the treatments outlawed by SB 1 can be medically necessary. The implication of these arguments is that the court should defer to so-called expert consensus. There are several problems with appealing and deferring to the authority of the expert class. First, so-called experts have no license to countermand the wisdom, fairness, or logic of legislative choices. Second, contrary to the representation of the United States and the private plaintiffs, there is no medical consensus on how best to treat gender dysphoria in children. Third, notwithstanding the alleged experts' view that young children can provide informed consent to irreversible sex transition treatments, whether such consent is possible is a question of medical ethics that states must decide for themselves. Fourth, there are particularly good reasons to question the expert class here, as recent revelations suggest that leading voices in the area have relied on questionable evidence and have allowed ideology to influence their medical guidance. Taken together, this case serves as a useful reminder that the American people and their representatives are entitled to disagree with those who hold themselves out to be experts, and that courts may not sit as a super legislature to weigh the wisdom of legislation. Wow, 4 really good points. But let's focus on the last one, the question of evidence. See, one of the points that Justice Thomas brought up during his dissent was the dependence of so many arguments on the work of the World Professional Association for Transgender Health, or WPATH. Over a decade ago, one of WPATH's contributors explained that WPATH aspires to be both a scientific organization and an advocacy group for the transgendered, and admitted that WPATH's standard of care is not a politically neutral document. WPATH's apparent willingness to let political interest influence its medical conclusions highlights this reality. States are never required to substitute expert opinion for their legislative judgment. And when the experts appear to have compromised their credibility, it makes good sense to chart a different course. It seems to me that a goal of advocacy is a direct conflict of interest to a so-called scientific organization. Yet these advocates seem to be the basis for so much of the transgender community's arguments for physically altering children to treat a medical condition. Now, meanwhile, Justice Barrett brought up the question of transgender individuals being part of a suspect class. The Sixth Circuit held that transgender individuals do not constitute a suspect class, and it was right to do so. To begin, transgender status is not marked by the same sort of obvious, immutable, or indistinguishable characteristics as race or sex. In particular, it is not defined by a trait that is definitively ascertainable at the moment of birth. The plaintiffs here, for instance, began to experience gender dysphoria at varying ages, some from a very young age, others not until the onset of puberty. Meanwhile, the plaintiffs acknowledge that some transgender individuals detransition later in life. In other words, they begin to identify again with the gender that corresponds to their biological sex. Accordingly, transgender status does not turn on an immutable characteristic. As I've been saying, transgender is not a physical condition, but a mental one. From Justice Sotomayor's dissent, we read, "To give meaning to our Constitution's bedrock equal protection guarantee, this court has long subjected to heightened judicial scrutiny any law that treats people differently based on sex." Now, once again, it seems Justice Sotomayor is quite comfortable not only making up facts to fit her agenda, but defeating her case in the same argument. She starts out by claiming that SB 1 discriminates based on sex. Then she writes this: Tennessee has taken a different tack. The state enacted SB 1 to categorically prohibit physicians from prescribing puberty blockers and hormone therapy for the purpose of treating gender dysphoria in minors. So which is it, Justice Sotomayor? Is Tennessee prohibiting physicians from prescribing these drugs based on sex, or are they treating gender dysphoria? You can't have both. This case presents an easy question: whether SB 1's ban on certain medications, applicable only if used in a manner inconsistent with sex, contains a sex classification. Because sex determines access to the covered medications, it clearly does. Except you've already stated that the prohibition on the use of these drugs is based on the condition being treated, not the sex of the individual. I guess, like WPATH, Justice Sotomayor is not going to let a little thing like facts get in the way of her advocacy. Now, ultimately, the court held the following. Tennessee's law prohibiting certain medical treatments for transgender minor is not subject to heightened scrutiny under the Equal Protection Clause of the 14th Amendment and satisfies rational basis review. Now, since SB 1 is not subject to strict scrutiny, the court affirms the Sixth Circuit's decision, leaving the law in place and unchallenged. The reason behind this decision, though, goes beyond the question of scrutiny. This case carries with it the weight of fierce scientific and policy debates about the safety, efficacy, and propriety of medical treatments in an evolving field. The Equal Protection Clause does not resolve these disagreements. The court's role is not to judge the wisdom, fairness, or logic of SB 1, but only to ensure that the law does not violate the equal protection guarantees. It does not. Questions regarding the law's policy are thus appropriately left to the people, their elected representatives, in the democratic process. I love it when a court stays within its own limits. Contrary to what Justice Sotomayor wrote in her dissent, judging the wisdom, fairness, or logic of the law is outside of the court's purview. That is the job for the elected representatives of the people. Setting aside whether sex transition treatments for children are effective, states may legitimately question whether they are ethical. States have a legitimate interest in protecting the integrity and ethics of the medical profession, which is exactly what Tennessee has done. They have found the use of puberty blockers and hormones to treat gender dysphoria unethical for minors. Beyond that, I believe Justice Thomas made a very important point when he wrote, "This case carries a simple lesson. In politically contentious debates over matters shrouded in scientific uncertainty, courts should not assume that self-described experts are correct. Neither courts, nor anyone else for that matter, should assume the self-described experts are correct. Or as the second pillar of the Constitution study process states, an expert opinion is still only an opinion until there's proof." I only wish more people would learn this lesson. So in the gender wars of the 21st century, the Battle of Tennessee goes to we the people. It goes to the state of Tennessee. It goes to what I would consider reason and logic. That these treatments, while they may be legitimate for adults, they are not legitimate for children. And they need to be protected from them, including, if necessary, from their parents, which is really a sad state of affairs. But that's the world we live in. That's the nation we live in. And if we're not willing to realize the truth, well, that leaves us in a pretty confusing state, does it not? Now, personally, the fact that this happened in Tennessee gave me a little extra pride. But this could happen anywhere. Makes you wonder, what is your state doing? Is your state protecting children from these transgender attacks on their body? Something you should look into. It's also something to consider of the protection of rights. As I always say, I hesitate to infringe on a parent's right to raise their children the way they see fit, except when it brings harm to children. And I believe there's more than sufficient evidence that puberty blockers and cross-sex hormones have long-term harm that they do to children. So that's what laws are for, isn't it? To protect us, to protect our rights, including the right of our children to grow up, to be the bodies they are, the people they are. And when they're adults, they can make a decision of how they want to live their lives. That's what liberty is supposed to be all about. Now, I hope you enjoyed this episode. I hope you enjoyed the content that we bring to you here. And if you do, it'd be nice if you could help support the work that we're doing. Yes, you can go to constitutionstudy.com/shop, click on the donate page and donate to our cause, or maybe buy a book or a t-shirt or a mug or something along that lines. You could also support our affiliates like, The Miracle of America. It's this course I found that looks at our history basically from the Pilgrims through the Founding Fathers. It helps explain why the Declaration and Constitution were written the way they were, why the federal government was created the way it was, why we are a union of 50 independent states, not just another version of a kingdom. I like the course so much, I made a deal with the owners to get you a lesson absolutely free. Let you try before you buy. Just go to constitutionstudy.com/1776 study guide, and you'll be taken to a custom landing page just for my listeners. You can read about the course, you can read about the instructor, but you can also enroll for a free lesson on God's natural law, the very foundation of our unalienable rights. And it's absolutely free. You get the downloadable study guide, you get an hour of content, either audio or video, whichever you prefer, and you get it all absolutely free. Now, if you like the lesson, you want to take the rest of the course, you can sign up there for just $17.76. But your journey starts by going to constitutionstudy.com/1776 study guide. You can also protect your rights with your cell phone. You see, I joined Patriot Mobile several years ago, not because of their 4G and 5G coverage, which is great, by the way, or their 100% US-based customer support, which is, again, very, very good, but because they are America's only Christian conservative wireless provider. They support the organizers and the policies I support. They take a portion of every dollar I pay and they use it to support organizations that are defending our rights. Freedom of religion, freedom of speech, freedom of the press, the right to be secure from unreasonable searches and seizures. So join me today. Go to patriotmobile.com/constitution. Find a plan that works for you. See if you're eligible for a discount. And then be sure to use the code Constitution at checkout to get free activation. Join us at America's only Christian conservative wireless provider. Use your cell phone to protect your rights. And it starts by going to patriotmobile.com/constitution to find a plan that works for you. And then don't forget to use the code Constitution at checkout to get free activation. The last thing you do, and probably the most important, is to share this content. Share the links, share the stories, share the news, share this information. And by doing so, share the blessings of liberty. And hey, maybe next time, bring along a couple friends when you join us here for the Constitution Study.